I object to that, Judge.
Anything else you'd like to say? Go ahead.
It's a known constitutional right that I have the right to go before a judge in order to gather my witnesses and present them before a judge. Having been brought in on a misdemeanor, the fact that it was a misdemeanor, he had no right to arrest or to prosecute, and he took it upon himself to do both. Judge, I do not. I really do appreciate you taking the time and patience with me. I know that it must be very frustrating for you, and I apologize in advance for that. But I am not comfortable with attorneys.
All right.
I have very little faith in the court system. I apologize. The statutes cannot be contradictory of the Constitution, and in that respect, they are. Also, what the prosecutor is not mentioning is that in the state of Kansas, in order to execute a probable cause without a warrant, he has to have exigent reasons. And his exigent reason was not listed as loss of evidence.
I see you filed some motions just moments ago.
I did, Judge.
Mr. Kelly, I'm taking a look at those to see if they're ones that can be handled
That's fine.
without notice. All right, Miss Gillette, are you ready to begin the hearing set for today?
I am, Your Honor. I haven't received any other copies of motions of any kind.
Mr. Kelly, you didn't serve the prosecution with copies of your motions?
I apologize, Your Honor. I was unaware of the need for that.
Yeah, they have a right to those motions. They should.
Yes, I thought it was all connected.
Okay. All right.
Do you want me to email them to her real quick?
Oh, Miss Gillette, do you want them emailed to you? I don't know if you're gonna have time to respond to them if you get them or not.
I won't have time to respond in writing because
Sure.
during trial.
Why don't you go ahead and send them to her, Missy? This isn't the appropriate way to do it, but let's go ahead.
And I emailed a copy of my response to Mr. Kelly, but I also have an extra copy here printed in my office beside the one to mail.
All right, so maybe she can take one down, take it to just exchange them back and forth. Well, no, you're gonna email it, right, Missy?
Yes.
Mr. Kelly, do you have your email available to you?
I do.
Okay, you might want to check your email if you haven't received
I
that
will.
response to motion to dismiss.
Okay. I'm actually not seeing it, Judge. I see one for the Zoom meeting from Missy, but I have no other emails.
You don't have one for Jill Gillette or Greenwood County Attorney?
No, I do not.
Okay,
I'll just walk one down to him, Judge.
Thank you.
Ms. Gillette.
Judge, you might look again because there was several filed. There was actually maybe 7 filed.
Are you talking to me?
Yeah, the motions.
Let's see, I counted up 1, 2, 3, 4, 5. Discovery for inspection 6. I think I looked at that, but I may have. Yes, I saw that. Let me look at 7 is the one called information notice. No, that's some of those kind of duplicate. The titles duplicate, not the contents. Yes, I did see all of those. Thank you, Missy.
Thank you, Jill. Appreciate that.
Well, no, there's another one I didn't see. That motion to suppress prior conviction. I don't think I saw that. Didn't see that. Okay, well, why don't we get started with what we can do today? There's a lot that's been filed here. Some of it we can deal with this morning. Some of it maybe not. We are now on the record in the 13th Judicial District, District Court of Greenwood County, Kansas. Would the parties please announce appearances? Ms. Gillette, which you're muted.
May it please the court, the state appears by Judge Gillette, County Attorney.
Is Greg Kelly appearing as the accused?
Thank you, Mr. Kelly. All right, we were set for jury trial tomorrow with the defendant representing himself, having previously signed a waiver. At pretrial yesterday, Mr. Kelly, the defendant, indicated that he still wanted his trial. He still wanted to represent himself, and he wanted to be heard on a document titled motion that he had filed. And then about 5-10 minutes before the scheduled court date today, he brought in 7 or 8 documents, handwritten documents, some typed, each titled differently. Some of them seem to have the same titles though. All right, so let's begin with what we're here for today, which was set simply to address a document that Mr. Kelly filed. And before I proceed on that, I guess I should go over the charges because those need to be addressed. Count 1 is the unlawful possession of the controlled substance THC and or marijuana after a prior conviction. And that prior conviction is addressed in one of the new motions filed. Count 2 is unlawful possession of drug paraphernalia, being marijuana roaches, which I believe would be considered rolling paper wrapped around marijuana and or THC in a small remainder amount. Count 3, no proof of insurance, which I understand the defendant brought in proof of insurance in a timely manner and the state dismissed count 3. So although it's referred to in the new motions, I don't believe it needs to be, but we'll address that at another time. Count 4, the registration offense. The defendant was pulled over initially for allegedly not having a current tag on his automobile, and the defendant addresses that as well. So with that being why we are here, there was a probable cause affidavit filed August 17th, and it was prepared and sworn to by Greenwood County Sheriff's Deputy Blake Fisher. The defendant had a surety bond that was filed August 18th of 2022. That was August 10th of 2022 and secured by Collins Bell Bonds in the amount of $7,500. We have the September 6th request for trial by jury, handwritten but filed by the defendant. We have a request for transcript. Not sure what transcripts really were of significance at that time, but the defendant asked for a transcript, apparently of first appearance. Transcript was completed. Did you pay for that and receive that, Mr. Kelly?
The transcript from what?
Okay. Well, I don't know what somewhat means. Did you pay for it?
Yes, I did. I paid for discovery, if that's what you're referring to.
Well, when you ask for a transcript, you usually have to pay and then they give it to you.
Are you speaking of a transcript record of the
transcript record prepared by a transcriptionist? It says Jerry Ann Knoll completed the transcript of a hearing dated 9/6/2022. And it was 20 pages. Did you file and receive that?
The state requested the transcript, Your Honor, as the defendant made an admission on the record during his first appearance.
My apologies, Mr. Kelly. Thank you, Ms. Gillette. I made that wrong assumption there. Okay. Then 10/18, there was the journal entry to dismiss count 3. That was the insurance. So, Mr. Kelly, that's off the table. That's off the documents. We don't have to address that anymore. That's been dismissed, even though you addressed that today in some of your documents, your motions. And then we have subpoenas apparently, and I'm just looking at the caption. And based on experience, that was probably for the jury trial. Then we have a long list of new documents all filed today, February 14th. 1, 2, 3, 4, 5, 6, 7 motions. But the one we are here on dates back. Well, I know I saw that yesterday, but it's not showing up in the document section. So let me look again. I didn't see it when I ran down the summary. It's there. Ms. Gillette, do you by chance have your copy of that document to show what date that would have been filed on?
The two-line to dismiss,
Right.
November 8th, Your Honor.
Thank you. There it is. All right, we are here on a motion pro se filed by the defendant November 8th, 2022 at 3:22 p.m. And it is handwritten and then literally says, captioned motion to dismiss, blank space, and I'm quoting, lack of evidence, KSA 22-34373, KSA 22-3402, parenthesis 3, parenthesis 4. That's all there is for this motion to dismiss. Is there anything you want to argue on this motion, Mr. Kelly? I will tell you that you should have by now the state's motion to that response to that motion that clearly it has 3 points.
Yes, Judge, it was pretty weak. I apologize for
It
that.
states that the motion filed was too vague, didn't state a claim upon which relief can be sought, and lacks any argument for which the state can respond. And frankly, I have to agree with that motion unless there's something you have to offer that can change my mind on that.
No, Judge, I appreciate you reviewing that motion at the time.
So are you still trying to pursue something with that motion or not?
That particular motion, no.
All right, so you're withdrawing that particular motion. The motion.
I am, yes.
All right, so we will note that motion, defendant's motion of November 8, 22, withdrawn by the defendant. And I would kind of add a little dicta there that I would have dismissed, I would have granted or denied it anyway. All right, now as to try to save time, we'll take a look at these new motions and see if there's any of them that we can deal with today, and I think there are, even though the state has not had adequate time probably to even read them, let alone respond.
Judge, if,
Just a moment, please. All right, the first one on my screen is the one called additional violations are as follows.
yes,
Let me see. Ms. Gillette, do you have that one in front of you?
Hold on, I'm looking for all of them.
All right, I'll let you go ahead and look through them. And I'll see if there's a more straightforward one first. Notice to
Additional violation are as follows. Is that what you said?
yeah, let's take a look
Yes.
at that one and see what we can do with it. Notice to the court filed by the defendant today at 10:52 a.m. And it alleges additional violations are as follows. 1, conflict of interest. I'm being tried by the state, judged by the state, and the state is also the victim. That's number 1. Well, what is your legal argument there, Mr. Kelly?
well, I don't see how I can get a fair trial when the state has their hand in every aspect of it.
Well, I think I understand what your argument is, but you have to understand all the people within the state of Kansas make up the state. And even though that is true, that we're all citizens of Kansas, if we live in Kansas and work in Kansas or work in Kansas, we do have different jobs to do. And Miss Gillette gets her paycheck, I believe, from the county of Greenwood, in that she looks out for that portion of Kansas known as Greenwood County. My job is one that gets paid by the state of Kansas as a judge. So Miss Gillette and I, we don't work with the same people. We don't represent the same people. Her job is to represent and protect. My job is to protect, but it is to protect both the defendant and the state, the citizens who are violated by the law. And I look at the evidence fairly impartially that she has. I look at your side fairly impartially. So no, Ms. Gillette and I are not conflicted in this case at all. The victims of the state of Kansas, some of them don't even know this is going to trial. Probably a very few of them do. Because as you said, the victim is the state of Kansas. When a law is broken of these natures, all of Kansas is affected by them. But again, there's just not a conflict. And I will rule right now, unless Ms. Gillette, do you have anything? If you want to respond to what he has said or what I have said, I'm inclined to summarily dismiss that, but I certainly would listen to what you have to say about that as well.
Your Honor, I believe that this matter is not a conflict of interest. I mean, this is how the courts are set up. They each have a separate, different, and unique role. And the only reason for conflict of interest would be whether or not I had a personal relationship with Mr. Gregory or something to that nature. And there's no relief upon which anyone could grant.
Mr. Gregory, anything you want to say on that particular allegation?
Not at this time, Judge.
All right. Well, I am ruling that number one of your additional violations, the conflict of interest, I am denying that. Number two, you assert that the deputy stopped outside his executive branch of power and acted under the judicial branch and used those powers which constitutes him operating under the color of the law. I'm not sure I understand that, but you're welcome to argue that, and I will certainly entertain it.
Judge, when he chose to not take me to a judge upon my demand, he therefore took the responsibility of the judge himself. And therefore, he bypassed one of my major, a substantial right, which was the right to gather my witnesses before a judge before he proceeded with any other action. And he chose to ignore that responsibility, which is part of his constitutional oath. And so he took it upon himself to use the judicial power, which he did not have privilege to.
So are you saying that he had a duty to bring you to the judge before he completed his investigation and made his arrest?
No, not well, in part, but mainly before I was booked or processed. I needed to see a judge before I was booked and processed.
All right. Ms. Gillette, are you in a position, are you prepared to respond to that?
Judge, I don't have all the research before me, but when an officer makes an arrest, he is to execute a probable cause affidavit, which is reviewed by the state and then subsequently by the court, when the court reviews the sufficiency of the evidence based on the probable cause affidavit that is recorded with the complaint. The probable cause affidavit is not public record. It is part of the judicial file, but it is often under the confidential seal of the court because it often contains birth dates, addresses, or specific information. In this matter, a probable cause affidavit was executed and was recorded with the court, and the court then records that for future use. So it would say that that is the proper protocol according to the statutes and the law under the state of Kansas, and that the officer in this matter followed his directive of having probable cause to effect arrest.
I object to that,
Anything
Judge.
else you'd like to say? Go ahead.
It's a known constitutional right that I have the right to go before a judge in order to gather my witnesses and present them before a judge. Having been brought in on a misdemeanor, the fact that it was a misdemeanor, he had no right to arrest or to prosecute, and he took it upon himself to do both. And the support of probable cause that I am privileged to was not a affidavit in support of probable cause. It was an affidavit in support of a complaint, which gave the prosecutor the access to continue from that point, because she had to have an affidavit in order to write up the complaint. The affidavit in support of probable cause has to be signed by a judge. And so therefore to my knowledge, he bypassed that process. And again, causing me due process violation by violating substantial rights. I realized that, police officers, law enforcement officers do not take you to the judge, but I specifically demanded that I had that right. And when I voiced that right became in effect, and he chose to ignore it. And therefore he extended his allowed power and took it upon himself to be the judge and denied me of substantial rights.
Your Honor, the
Yeah.
Kansas statute is Kansas Statute 22-2401. The officer that has probable cause to believe that the person is committing or has committed a felony, a misdemeanor, and the law enforcement officer has probable cause to believe that, the person will not be apprehended or evidence of the crime will irretrievably be lost unless the person is immediately arrested. We know that under the case law, that when you are in an automobile, it gives an inherent grounds for believing that the information can be lost because automobiles are inherently mobile, and therefore it is appropriate to arrest for misdemeanors when they are automobile related. And so therefore there is grounds and statute that support probable cause arrest, which is what we have in this case.
If I might interject.
Final comment, sir. Go ahead on this issue.
Okay. The statutes cannot be contradictory of the Constitution, and in that respect, they are. Also, what the prosecutor is not mentioning is that in the state of Kansas, in order to execute a probable cause without a warrant, he has to have exigent reasons. And his exigent reason was not listed as loss of evidence. Technically, he didn't list an exigent reason, although I believe that he was stating that his safety was the exigent reason. But that does not give him a right to do a warrantless probable cause unless he has exigent reasons. And he did not.
Well, The office, as Ms. Gillette correctly cited the law, the officer can arrest either with a warrant or under probable cause. And in this case, he made the probable cause arrest because of the possession of marijuana and paraphernalia. There is exigency in that. Again, as Ms. Gillette stated, because of the mobility of automobiles, the nature of drugs inside of a car, that evidence could have been lost. And the law is quite clear that that can and does create the probable cause for the arrest. So on that particular issue, at this time, I am going to find that the law relied upon is constitutional and does give the officer, based on the affidavit submitted, probable cause to make the arrest. And that was determined. That might be one we could have an evidentiary hearing on, but the affidavit, based on the affidavit the officer filed, does, in this court's opinion, amount to probable cause to support the arrest. But if we do, again, if we need to have evidence independent of the affidavit, that can be revisited. But at this time, that is denied. That portion of the motion. Counts 3, no affidavit in support of the warrantless search. Again, that affidavit is very clear. It is part of the file that the court takes judicial notice of, so that is denied.
Is that sealed?
That does go through a sealing process, but you can get a copy of that if you haven't already.
He has a
I
copy of
have.
the affidavit.
He does have a copy that was supplied when he asked for it originally.
Yes,
It's
but
part of
Judge,
it.
Okay.
I have to object because it cannot, in my impression, it cannot be an affidavit in support of probable cause unless it was signed by a judge. It was signed by a notary.
Well, the warrant, the inactive warrant was signed by the judge based on the probable cause affidavit.
And I never received that. So I would like
Okay,
to
well,
object.
let's sort through that because Ms. Gillette says you were given that. Let's make sure you know what it looks like since you're representing yourself.
And I would also,
And
If
again,
I'm-
are you certain that you do not want an attorney to represent you, Mr. Kelly?
Judge, I do not. I really do appreciate you taking the time and patience with me. I know that it must be very frustrating for you. And I apologize in advance for that. But I am not comfortable with attorneys.
All right,
I have very little faith in the court system. I apologize.
nothing to apologize for, sir. Affidavit was filed August 17th of 2022. And it should say electronically filed and then give you the information about the court case number. And then underneath of that, it should say affidavit. And it begins, I, Deputy Blake Fisher. You don't think you have that document?
I do have that document, Judge.
That is the affidavit. When we refer to affidavit, that's a 3-page document. And the last page says Deputy Blake Fisher, and it is subscribed and sworn to August 11th, 2022 by Gary Murphy, Notary Public. And then you should also have, typically there is a warrant signed by the judge. Do we have one of those, Ms. Gillette, that you see?
In instances where the person is arrested based on probable cause, the state must file a complaint against the defendant.
Mhm.
There isn't an actual warrant because they were already effectuated upon arrest. So they are not re-arrested. Sometimes we issue inactive warrants, but in this matter, because he was already placed in custody, he was not rearrested. And the case law on that is State versus Goodrow, 506 Pacific 3rd, 918. It's Kansas case number 121,944, decided in 2022.
All right, well, that's one of those things, even though we're in the same judicial district, the counties do it differently because historically Butler County does file what they refer to as an inactive warrant after the court has reviewed the affidavit. And then we still sign off on the warrant, even though it's labeled inactive, but it shows that the affidavit is approved by the court and supported. But Ms. Gillette, you're saying that Greenwood County does not do that practice. They rely strictly on the probable cause arrests in the affidavit. Is that correct?
Yes, for misdemeanors.
For misdemeanors. Okay, and the case law site is 121 Kansas 944.
Yes.
Okay, and you said that's
21,944 is the case number. There isn't a Kansas site yet because it hasn't been published.
okay. Okay, so it's 506 P 3rd.
Pacific 3rd.
And it does it have a page number yet?
918.
Okay, and it's a 2022.
Mm-hmm.
Okay.
And Your Honor, when it comes to misdemeanors, that goes over that in that matter. The defendant has to be brought before a magistrate within an appropriate amount of time, depending upon whether or not they remain still in custody or whether they are released from custody. The procedure under the Kansas law has been followed in this manner. The defendant had a first appearance. His first appearance being on, he had technical issues on August 30th and was moved to September 6th of 2022, of which there is a transcript of the first appearance.
All right, so Mr. Kelly, what you might want to do is take note of that case she cited. What was the name on it?
State v. Goodrow.
Good.
Goodro.
All right, State v. Goodrow, and it's 506 Pacific 3rd. That's the set of books it's in, and 918 is the page where that can be found. So that may answer that question. I think the better practice, I like the practice better that we do in Butler, but I'm not going to say that Greenwood's doing it wrong either. I don't think we are. I'm finding that
what feels like filing everything possible is actually working against him. The judge isn't rejecting the ideas, he's rejecting the structure. In court, clarity equals credibility. When arguments are scattered, they signal a lack of legal grounding, and that makes it easier for the court to dismiss them without deeper consideration.
and that
Well, if I may object to that, I would like to object on that ruling.
well, I would suggest, sir, what you do is we rule on these, we pare them down.
Okay,
And if you want to file a motion for rehearing, because the state's probably not
Okay.
liking the way I'm doing this either. I know Ms. Gillette likes to do her research and write her answers out. I'm trying to find a way to
as long as I have
streamline
that,
some of these volumes of
okay. As
documents.
long as I have that option. Thank you, Judge.
And deputy creating his own exigent reasons. Tell you what I'm gonna do. I'm gonna order that these be written up in more detail, because these are just too vague. If you'd write up more reasoning for these, and then I'm gonna give Miss Gillette time to respond in writing
Okay.
if she wishes, because you've got so many. I'd hope to.
I would appreciate more time. I did not have less than 24 hours to put this portion together. So if I could rewrite it and be more,
I would beg to differ with you there. I think you've had, since this case started in August, to do whatever you wanted to do on it, but
Yes, Judge, correct.
this is going to be so cumbersome, and it's 1:45 and we haven't even gotten but into 4 points of your multi-page motion or whatever you want to
Judge, I
call it.
apologize.
Multiple, so. Is there anything critical that we have to deal with today from either party?
The biggest thing was what I am calling a due process, the biggest due process violation, which is the complaint that I filed with the sheriff's department that I gave them for review prior to me sending off a claim. And it was based pretty much solely on the fact that I was not given the right to be taken to a judge prior to booking. That was the biggest due process violation. There were a couple more, but that was the one that I had written a complaint out to the sheriff's department for review.
Okay, well, and that one I do, that one I think I've already addressed, that under probable cause, he didn't have to bring you to the judge, that he did act properly in that one. I'm very confident of that. Okay, well, let's set this over. We're not going to be having a jury trial tomorrow. So, and I'm going to have you limit this to get all of these pared down. I'm going to give you about an hour, Mr. Kelly, to argue everything you want to argue. So make sure
Okay.
you really refine these.
That's
And
fine.
put
That's
them in
fair.
a way that they make exact sense to the state and to me as to what you're actually saying.
Okay.
And so, Missy, can you give me about an hour? And did we reset? Let's reset this for jury trial June. What's that date? June 13th for pretrial?
June 12th for a pretrial and June 14th for the jury trial.
All right, so I'm going to move your jury trial to June 14th and 15th. Your pretrial will be June 12th. And then I need about an hour before that June 12th date for his motion hearings.
Okay.
And if he files a motion to suppress in the traditional sense, then we will need to have evidentiary hearing. So I think I saw something called motion to suppress, but again, I'm not
Yes.
sure that they meet
That
the,
was
but you've got to meet the legal definitions for these things. It's not enough
Okay.
to use the legal terms. You have to know what they mean.
I will get help with that.
Okay, and have legal cause.
Thank you, Judge. I appreciate your patience, and I know it's frustrating for you and it's frustrating for me, but probably not as much as it is for you. And
Well,
I do
no,
appreciate-
I do my job, and whether it's frustrating or not, that's no concern for either one of us.
Judge, if we're
Yes, Ms.
having
Fuller.
this pretrial on the 12th of June, what day are we having the
The jury
Oh,
trial?
the motion?
Missy hasn't been able to give me that date yet. She will as soon as she finds it.
Do you want to do like April or May?
It makes me no difference. We can do it sooner rather than later. Ms. Gillette, do you have a preference when we do it?
No.
But I want all the issues heard at one time. I don't want to do it like we did where we had one motion filed a couple months ago, and then we have a whole bunch of motions filed 5-10 minutes before we're supposed to start today.
I agree, Judge.
Okay.
Thank you for that extra time.
All right, so whatever day you have, Missy, about an hour
Okay.
at the most.
April 7th, we could start at 9 and we could actually go till 11 if it took longer.
Okay, but I don't want to encourage it to go longer. I want everybody to get in there and be succinct. So, Missy, what day of the week is that?
It's a Friday.
Okay, Friday, April 7 at 9 to 11, you said?
Yes.
Does that work for both parties?
It does, Judge.
Okay,
And that was on the motion hearing. And then the jury pretrial was on January or June 14th and 15th.
the pre-trial is June 12th. That's what we had yesterday.
Okay.
And then the jury trial itself, where you're here with live witnesses, we're picking witnesses, they're deciding your case. will be June 14th and 15th.
Okay.
And I just caution you, Mr. Kelly, because you told me you don't trust lawyers. Don't go out and get advice from non-lawyers because first of all, it's illegal to practice law without a license. And you'll be having some folks committing new crimes and you'll be potentially responsible for soliciting illegal conduct.
I'll actually pay for an advisement.
Right, that's what I was gonna say, because make sure you go to somebody that not only you can trust, but can legally advise you.
All right.
If you get somebody that you want to hire, you think, hey, I can trust them all the way through, that's great. And I'd remind you again, if you can't afford an attorney, you're welcome to apply for a court-appointed attorney.
That's not an issue, Judge, but thank you.
All right, anything from the state, Ms. Gillette?
No, Your Honor.
All right, thank you both. Thank you, Missy. We will be in recess at this time.
This entire hearing turns on a pattern that shows up in many sovereign citizen-style defenses, redefining how the system works instead of working within it. The defendant isn't refusing to participate, he's trying to replace established legal procedure with his own interpretation of rights, jurisdiction, and authority. But the courtroom doesn't operate on personal interpretation. It operates on structure, precedent, and procedural rules. And every time he introduces arguments like color of law, demands immediate access to a judge, or challenges probable cause based on misunderstood standards, he's not just making a legal claim, he's testing the limits of his own credibility. The judge actually gives multiple off-ramps here. He explains the roles of the state, clarifies arrest procedures, and even offers time to refine arguments properly. Those are opportunities. But instead of narrowing focus, the defense expands. More filings, more claims, more complexity. That decision has consequences. Because in legal settings, volume doesn't equal strength. Precision does. And by the end of this hearing, the case hasn't moved closer to dismissal, it's moved toward delay, stricter scrutiny, and a higher burden on the defendant to present something legally valid. What looks like asserting control is slowly turning into losing it.